TransUnion comes in, and this case involves several violations of the Fair Credit Reporting Act by TransUnion. This is a law that's 50 years old. And in particular, the facts are kind of outrageous. The credit reports of the plaintiffs had notations that they were potential terrorists, and these were false. And the plaintiffs had some difficulty addressing the situation and finding out about the situation and so on. Ultimately, the Supreme Court said that only those plaintiffs whose credit reports were disclosed to others could have standing to bring their suit. The rest of the plaintiffs didn't have standing because it wasn't a concrete injury, and that therefore they couldn't bring their case, even though you had this cause of action. I think it's a very troubling decision. It's a really troubling trend. Standing doctrine is modern standing doctrine is actually a creation of the court from the 1970s. The requirement was really designed to existing requirement for standing, which was the violation of a right. And Congress has the power to define whatever rights it wants to define. But this court, in the guise of so-called, conservative principles, essentially is doing the opposite in a very activist way, rewriting Congress's laws and telling Congress, no, you can't define a right the way you want to define it. You can't provide the kind of remedies and enforcement mechanisms in a statute that you want to provide, because we won't let you bring it in court. So it's a very aggressive move to aggrandize judicial power. And the irony is that standing is actually normally a way of the court to be restrained in its power. It's something of judicial restraint. But ironically, now it's being used as a way to essentially try to nullify something Congress did. And the thing that makes it even worse is that the private right of action in FCRA was a trade for immunity from state law claims for defamation and invasion of privacy. So I think this is this doesn't mean that, hey, you don't have to comply with federal laws. It basically means that, the private right of action in federal laws can be limited in certain ways by courts. The test for limiting it is actually a really mushy test. It's kind of looking at, well, kind of what's traditional in the common law.